Public Education and First Generation Initiatives now calls this oversight hearing to order. Today is Tuesday, July 19, 2016, and it's 12:06 p.m. And the agenda items, we have policies and procedures regarding student complaints of sexual harassment and sexual violence, policies relative to student safety. I welcome all of you who have taken the time to attend this oversight hearing. I thank you for your presence here this noon. The committee has invited the Guam Education Board today, and the purpose of the oversight hearing is to receive a status report from the Guam Education Board in regards to the policies and procedures regarding complaints from students of sexual harassment and overall student safety. I would like to ask each of you to please introduce yourself for the record by stating your name and your role. Starting from Mr. Adler.
Good afternoon. My name is Peter Alexis Adler, and I'm a member of the board, 7th Board of Education.
Lourdes Benavente, member. Roxy Tainatongo, Vice Chair.
Lourdes Nicholas, Chairperson of the Guam Education Board.
Ken Charglove, member of the Guam Education Board.
Ryan Torres, Guam Education Board member.
Okay, thank you very much. And I want to acknowledge my colleagues for attending this morning's roundtable. I'd like to introduce the Vice Chair of the committee, Speaker Judy Wanpat, and to my right is Vice Speaker B.J. Cruz. Thank you very much, colleagues, for attending. Let me state for the record that this oversight hearing has a limited focus on whether the procedures and processes are followed, and whether those are consistent with the federal and local statutes and guidelines on the handling of sexual harassment misbehavior allegations. As part of this oversight hearing, it is necessary to secure and clarify information about existing policies and to make a determination as to the manner in which violations are investigated and handled in a way that is respectful to both the person making the allegations as well as the individual who is the recipient of the charge. We are not here to investigate the allegations themselves, but instead the manner in which the Guam Education Board handled this matter. In this particular case, the complaint is against superintendent. Consequently, the Board of Education had to take the case, manage the case, conduct and or manage the investigation, and make a determination. In this particular case, there were 7 members of the board had been reported to, along with the superintendent, to make a charge of extortion and blackmail and refer it to the Guam Police Department and the Federal Bureau of Investigation. This raises many questions, not because of the alleged extortion itself, but the fact that a majority of the board chose to support a course of action connected to the original charge of sexual misconduct, which, by your own admission, has not been fully investigated. The FBI and the GPD investigation is about a crime, which apparently a majority of you believe occurred. That will be investigated and completed in its own course of time. This is how law enforcement works, and we all respect that. However, that is separate and apart from the original complaint of sexual misconduct or harassment against the superintendent. And this warrants an administrative investigation in which the board has direct responsibility to oversee, and which should have been conducted independent of the superintendent because he was being charged. The manner in which this investigation is conducted will affect the integrity of the system, the Guam Department of Education. So let's deal with the alleged crime of extortion first. I have asked you for a copy of the letter charging, quote, extortion, end quote, even under the Freedom of Information Act request. You have not provided the letter or any related documents under the logic that disclosure of those documents will compromise the investigation. Let me ask you some questions which will not compromise the investigation. These questions are important because of the fact that 7 members of the Guam Education Board signed the letter, carries some official weight or sanction, even if none is possible or desired. This is an important statement about how you and the public see board actions, not whether extortion occurred or not. It was reported by the superintendent that a criminal complaint was filed against 5 individuals and that 7 board members signed the complaint or endorsed the complaint. I am not sure about how this was communicated to the authorities. Let me ask you questions which do not speak to the substance of the charge of extortion, nor will it require you to compile information. Question 1. Which of the Guam Education Board members signed the letter? Okay, so there are 6 of you present who signed the letter. Who prepared the letter? Did you prepare the letter? Who prepared the letter?
The letter was prepared. I do not know who is the author of that letter, but the letter was prepared and presented to the board by the Guam Department of Education superintendent.
Okay, so was it on the Guam Education Board letterhead?
No, it is not.
Was it on the GDOE letterhead? Oh, sorry. You were saying something, Madam Vice Chair.
It was on the letterhead, I noticed, because at the very beginning it was not. Then they went ahead and retyped it, and it was placed on the letterhead.
Which letterhead was it? Was it the Guam Education Board letterhead, or was it on the Department of Education letterhead?
It was the Department of Education letterhead, Office of the Superintendent.
Since it was the majority of the Guam Education Board signing on, does this represent an official position of the board?
The intent of our signatures was to support the superintendent's filing of his complaint to both the GPD and to the FBI.
Okay, so was that an official position of the board as a whole, given that there were 7 of you that signed the letter?
Yes, it was.
So was a meeting held on the subject of forwarding the letter or any documents? Did you hold a meeting? Did somebody make a motion to sign the letter of support?
Yes.
Was that,
Yes.
okay, and was that an open meeting?
Yes, it was.
And so who was it who made the motion? Yeah. Yeah, and the
I
date.
made the motion.
You made the motion, and what date was that?
I believe that was June 21 or June 22nd during an open meeting, but the June 22nd was the continuation of the June 21 executive session.
So it was an open meeting. It was during the open meeting
That the motion was made.
that was made, and you actually had made that.
Are there minutes of that meeting?
What I understand is that the discussion during the executive session, it was recorded.
But was the meeting on the 22nd a continuation of the executive
Of the
meeting?
21st, correct.
Was the meeting on the 22nd recorded?
The executive session on the 21st was recorded, and the board also requested the superintendent to ensure that the June 22nd meeting was also recorded during the executive session.
Was it recorded?
It was recorded.
Was there since there was a motion made and a motion passed, is there a resolution?
The motion was made when we went into public session following the executive session.
And so was there a resolution?
And there was a vote that took place.
Is there a resolution signed by the secretary that this resolution was passed pursuant to a discussion in executive?
Vice Speaker, that minutes will be adopted on the 25th because we transcribe our minutes, then it goes on the next board meeting to adopt the minutes of the meeting to approve.
Because I was wondering why I hadn't seen those minutes.
Because until
It's until the
the
meeting will be
25th
next
of July.
Monday.
Correct, that we will be adopting that.
Approved.
Approve them, the minutes.
Okay. All right. So basically, I just want to go back. So what you had noted to me during our meetings, Madam Vice Chair, was that the results of your fact finding, there wasn't a formal investigation at that point.
Correct.
You had fact finding, and that was the basis for making a decision.
Actually, what we call it is mediation. We were attempting to mediate.
Can you explain the mediation process?
The guidance was provided by the DOE Legal Counsel to try and attempt for a mediation. And the board as a whole wanted us, the two leaders, to handle that matter, and we did.
What's the definition of mediation?
To try and have the parties have an understanding and bring the two parties together to ask questions of each other, what was meant, and that was our whole purpose.
Have you conducted any mediations besides this one? Is this the first mediation of any sort that the
Not
board-
with the superintendent. It was
Not with the superintendent. But
no, this was the first one.
Were there any others, not the superintendent's case, but any other mediation? Have you done this before in the term of these board members?
Yes, we did, Vice Speaker.
And what was, without names, what was the outcome of that mediation?
It was resolved. One was resolved. The second one is still pending.
The one that was resolved, how was it resolved?
The two parties got together and talked and ironed everything out.
When I used to have my other hat on, mediation usually meant people would come in and make offers of how to be able to resolve. was the mention of any, what would be mentioned in these mediations as possibilities of resolutions?
I'm going to let the chair answer the opening
In
of that.
the mediation process, we had asked the party how would they like to resolve the issue. What would they like to get out of that process? That
you.
was the attempt that we made.
And that was, I saw that in one of the comments. What do they want to get out of the mediation?
How do they want
Yeah.
to resolve it?
And so someone mentioned that they wanted tuition payment or some kind of money. Is that a mediation or a possibility of resolution?
Well, first of all, Mr. Vice Speaker, let us be clear. The two cases that we're making reference to has nothing to do with any sexual harassment or sexual misconduct. It has nothing to do with that. It is very different. The previous, when we got together, it's really to look at what are the issues pursuant to, using our board policy 914 as a guide to help us resolve at the lowest level possible. But it has nothing to do with any sexual harassment case. And we brought the two parties together, and the idea is to resolve it at the lowest level possible. We took care of that. So,
Yeah, okay, even if it doesn't include sexual harassment, all right? Just a mediation. In the mediation, is there a possibility that somebody's going to say, I will resolve this by a payment? Okay, let me take an example, okay? I was contacted by a parent that one of their children had been injured in one of the athletic events on campus. Okay, and in an attempt to mediate, if the mother came in and said, "I want you to pay the hospital bills, and I want you to pay for my pain and suffering of X number of dollars, and I want you," would that be an appropriate request by a parent to ask in a mediation about trying to resolve a complaint about hospital bills that a child incurred at school?
if I may, Madam Chair, something like that, Mr. Vice Speaker, that specific issue goes directly to the superintendent, and then the superintendent, among his management team, will go to the appropriate deputy superintendent, and they will address that at that level. It does not come to the board's level.
But if it came to your level, I'm trying to understand what you guys would expect and have experience in the past of what is an offer for mediation, or what do you want out of this, as you put it. I mean, because when you put it as what do you want out of this, what would you believe to be appropriate request of what you want out of it, without crossing the line and it being extortion for asking for, this is what I want. You ask me what I want out of this, this is what I want out of this. And then I make the offer and I say, this is what I want out of this. Aha, extortion. How are you supposed to receive these mediation? What do you want out of this? Well, I want this, I want this, I want this, I want this. Maybe it wasn't even money, but just the fact that they wanted certain things. That's, when does it cross into extortion? I'm trying to figure out. And especially if you're the one that's asking. So I keep wondering about this mediation. Because it scares me, the thought that you guys can mediate, and then all of a sudden, when somebody asks for something, it becomes extortion.
Senator, we did this at the advice and suggestion of our legal counsel. We did attempt, it did not go through.
Okay. But you specifically, in your own words, what do you want out of this, right?
That's correct.
Okay.
Can I just continue on? So did I hear you correctly that it was then advised by legal counsel and you attempted to have then that meeting of two individuals? Was legal counsel going to be present, or was any one of the board members going to be present as well?
No, we did not have the legal counsel. This was just at the board's request for the two of us to handle the matter.
When you
And
say
so
the
when
two,
when we sought guidance from the legal counsel, he advised us to try and do mediation.
So who are you said the two of us? Who are the two of us, meaning? Oh,
The vice chair
The
and
vice
I.
chair and the chair. So
That's right.
then you suggested that both of you sit in that meeting.
No one. We did not have anybody else during that process.
So did the meeting happen?
The meeting did occur, but it did not proceed.
Okay.
Okay, now you're going to need to explain to me what it occurred, but it did not proceed.
It did not proceed to continue because the party did not want the other party to hear what they have to say.
Mr. Speaker and members of the legislature, because this is an active investigation being conducted by the FBI, by the Guam Police Department, I also understand that the Attorney General was requested to conduct an investigation. I just want to make sure that we are in full compliance of FERPA. We are in full compliance of the certain information that we can disclose. I just want to make sure that we are not going deep into the discussion until these issues are concluded by the appropriate authorities. We can probably discuss the process. I am not sure if we can.
And I'm trying to figure out the process. Is the process recorded? Because there are no witnesses, you didn't invite legal counsel, or was legal counsel even invited?
The process is recorded to the extent that whatever documents was given to the board is transmitted directly to the legal counsel and to every document that was submitted to the legal counsel. I would prepare a cover memo indicating these documents have been received for your examination, review, and disposition. Please provide guidance to the board on the next course of action. I ask that you give this matter your most urgent attention.
Okay, good. So but there's no tape recording like you do the executive sessions.
Tape recording?
during the informal.
No,
Doing these mediations aren't
no,
electronically recorded.
no.
So it's just
It's an informal way of seeing what we can do to get that communication going and have a good understanding of what their issues are. But at the same time, all these documents have been forwarded to the legal counsel.
and I'm trying to understand the process. do you do any investigation before that, before you start the mediation, to understand what the underlying issues are?
There was never a formal investigation, sir.
But then how could you make a determination of what could or would be appropriate? Unless you knew a student was injured and you had done an independent investigation that this child had been injured at a athletic event on a GW campus or a JFK campus or at Guam High, should we not complete the investigation of whether or not that injury had occurred and where it had occurred before I could bring the parents in and the school and try to mediate?
Yes, sir. And in our policy on Board 409, the current policy states that DOE employees who engage in harassment, intimidation, bullying, cyberbullying, sexting, and sexual harassment of students or other employees shall promptly be investigated and appropriately reported by the school principal to the Guam Police Department and the Deputy Superintendent of Educational Support and Community Learning. Disciplinary action shall follow the DOE personnel rules.
Was this policy complied with in this case?
We cannot answer that question. The board does not manage operational cases. I'd like Mr. Joseph Sanchez, the acting superintendent, to respond to that question.
But let's just focus on the complaint that was brought to your attention. Okay, so you don't have the operational, you don't have supervision over the principals in the school system. That's the superintendent. But the case, the complaint was brought to your attention, correct?
That's correct.
Okay, so if the complaint was brought to your attention, then the standard operating procedures of the department, which you have read, would have been applied to the board too, correct?
Yes.
Yes. And so, Madam Chair, when you received the complaint, which I believe was May 26th, what was the date of the complaint?
May
that you first-
23rd, 2016.
Okay, when you received the complaint on May 23rd, based on the board policy that you have read to us, did the board then take action at that point? What action did the board take to comply with that policy?
The action that the board took on the night of May 23rd, 2016 was we asked the legal counsel to come into that meeting. At that time, we handed him the document that was given to the board, and we specifically asked him to look into the matter and work closely with the Attorney General's office. That was the instruction of the board.
And that was in May
23rd.
23rd. You have been at the school system, Madam Chair, and also Mr. Chargloff and Madam Vice Chair. And so the standard operating procedure, I think you can recite that to me, which is upon receipt of the complaint, then what's the next step that you take?
I can respond. Thank you. The next step we take is that we quickly conduct, in my case, at the school level, I quickly conduct a formal investigation on the case. Once I have the information, I promptly report that to the district office, to the superintendent. In the meantime, I will also contact the Guam Police Department as required by law. I contact the CPS if the student is below the age of 18. I'm required to contact CPS within 48 hours. And then refer the case to the, in my situation, I refer the case to the Superintendent of Education for her review or for his review and disposition. And then the employee, then respectively, I also send the employee to the Department of Education for further action of the Superintendent of Education, whether to place the employee away from the work site or to place the employee on administrative leave, either with pay or without pay. That is up to the discretion of the superintendent.
Okay.
The employee remains away from the school site until the investigation is completely done and concluded, and then the district office then refers the employee back to the work site once it's cleared.
So applying that same standard operating procedure in this case, let me ask. So what did you do then? Besides contacting the legal counsel? Did you file the complaint with the police department? Did you report the complaint with the police department? Did you remove the one who's being accused from the environment or put them on administrative leave? Did you immediately conduct an independent investigation?
There were discussions while I was away, and I'm going to ask Mrs. Tainatungo to explain what happened.
While you were away, this was there on the 23rd, and I'm now embarrassed to admit I was at that meeting on the 23rd, wasn't I? Unfortunately, I left before anything happened. I was sitting in the back corner, and I kept wondering what was going on within an arm's length of me, with the principal being told, why'd you take somebody off the agenda? And there was this whole argument I could touch both of them from where I was sitting and could hear all. Had I known this was happening, I would have stayed. I was there to make the presentation, exhorting and asking you to please adopt a new policy of absolutely no fraternization. But I didn't realize that all of this was going on around. I made my presentation, and there was mention that you were going into executive session, but I didn't realize what was. So what did you guys do on the 24th and the 25th of May?
We did not take any action at that time.
When was the first time you took action?
Vice Speaker, when on the May 23rd, that was when we received the document. The chair already said she called legal counsel in for advice. At that time, after that, I think it was the day after or 2 days, Madam Chair, you better answer that she did instruct the superintendent that I don't know if we should go into this because we're going right into the case again, and we don't really want to compromise the case, Vice Speaker. So
okay.
I'm not
then
sure what
just
can we
without
say.
making was the policy complied with that you have there? As was read, as is memorized by the two of you that are principals who know this policy, did we comply with the policy as is passed?
The policy No, we did not comply. The policy, however, focused in on all schools, the applicability of the policy in terms of the standard operating procedures, all schools within the Department of Education.
And did it exempt anybody?
Better yet, do you have a separate policy maybe for adults?
For the superintendent. If you didn't, you're stating, Madam Chair, that policy was applicable to the schools.
The standard operating
The
procedures
standard
and the
operating
policy
procedures.
itself.
Then are you saying that there's a different set of standards for the superintendent?
No, we're not saying that there's a different set of standards. What we're saying is that the board is working to make revisions on the current policy to address non-school-based employees. Yes, as it is right now on the board policy, it just talks about the role of the school principal, the role of the deputy superintendent, and how to go about it in terms of the procedures that were outlined on August 2014.
Okay. But we're all familiar with Title IX, correct? Yes. Okay, you're familiar with Title IX, Madam Chair? And the requirements of Title IX. I think I sent you a copy of even the student rights.
That's right.
Okay, the student rights. And I think you have that right there. So there are specific procedures that have to be followed under Title IX. We are required to comply with those procedures as well, correct?
Correct.
Yes. So in Title IX, it does state about the school, but it's any student, any adult to whom they are making accusations, correct?
Correct.
Okay. So even with this, wouldn't this be applicable in this case?
Yes, it is, Madam Chair. I just want to say that the board did act promptly to address an allegation of sexual harassment in several ways, and I believe that was part of the FOIA response that was provided to your office. The board did instruct the superintendent to refrain from all contact with the students and subsequently approved administratively for the superintendent.
How many days after the 23rd of May was that?
What was the question, sir?
How many days after May the 23rd were those instructions and orders given?
How many days?
All,
Almost 2 months.
that's
I
correct.
think
That-
July the 15th. Okay, so
I need to provide clarity.
okay.
On that evening, on the May 23rd, two board members asked the question to the legal counsel.
That's correct.
Are the rules and the policies apply to our superintendent of education? Is he an employee of the Guam Department of Education? And do these rules equally apply to any classified or unclassified employees who work for the Department of Education? His response was, allow me 30 days to review the documents and to address that question. So the board acted promptly, again through the advice of the Guam Department of Education legal counsel. I'm not sure because I have not received his findings, nor have we been provided any written documentation or even an oral report after the 30th day. And so that is what we did. It was a step, we received guidance from the legal counsel on a step by step. And we have all those documentations that the chair has really provided our legal counsel every time. And the advice, because I was not part of that, I wasn't there, and maybe the chair can describe what the processes, because I know that we are interested whether or not we follow the processes pursuant to board policy, pursuant to personnel rules and regulations, our own SOPs, and Title IX. And there are areas here that we consider that we need to come back as a board. We need to come back as a board and review this one more time. We are now in the process. We have already held 2 or 3 meetings, and there's another one coming this Friday. We're reviewing it. We're making some changes, amendments, adjustments to the policy.
And that's very good,
Yeah.
Mr. Chargloff. That's very good that you're revisiting, because I think through this you are seeing where the holes need to be filled.
That's right.
But we're still looking about we're still staying with this, because Title IX has been around for decades. You know that. And it specifically states here, and we've gone through all the training, what are the school's responsibilities to address sexual harassment and sexual violence in the schools? It occurred in the school, correct? The allegation was that was with a student. A school has a responsibility to respond promptly and effectively. A school. Are you part of the school system?
Yes, we are.
Did this involve a student?
Yes.
Are we receiving federal funds?
Yes.
Yes, we are. Okay. So if a school knows or reasonably should know about sexual harassment or sexual violence that creates a hostile environment, the school must take immediate action to eliminate the sexual harassment, sexual violence, prevent its recurrence, and address its effects. So that was the line of questioning that I was stating, that this has been in the policy. This is your existing policy. It was adopted in 2014. And so to the extent that while you had asked for the legal counsel's advice, as a school leader that had been there, you know this, Mr. Chargloff and Ms. St. Nicholas, that these are very, very critical federal guidelines for how we should treat complaints, especially by our students, how we should treat complaints by even our adult employees, because it is of public concern. So we go back then to going back to that letter that you had signed, that 7 of you had signed. Before I go with that line of questioning, I actually was wondering if, Dr. Cruz, you did not sign the letter.
Yes.
May I ask you why you did not sign the letter?
It wasn't clear. And the charges, especially the charges, I felt that I was not involved in the discussion. And therefore there were still some information that still had to be provided to the board. And when they asked the board, and we went down to an individual, questioning, are you going to sign it? I said pass, and in passing, I didn't sign it because I felt that it wasn't clear exactly what really was going on, and the superintendent was supposed to have provided a documentation to that effect. And I wasn't privy to the documentation after it was signed by the people who were there.
Okay.
So I couldn't have signed it, and I did pass, and I said I would not sign it because in its present state I wasn't comfortable with what was being presented for the board to adopt or to support. Thank you.
Thank you, Dr. Cruz. So that was an official action, correct? You had made that known. But I believe that it was an official action that was ill-advised in light of the fact that you did not have a formal investigation going on. The complaint there that came from the student had to do with the sexual harassment allegation. That was not addressed immediately. You did not follow the standard operating procedure that the school had adopted for every other employee and student. But yet, you took official board action to support the allegations of extortion or blackmail, and it's not clear to us or to the public the basis for that. And while you supported that, you failed to address the heart of the complaint in the first place. In my view, and what you are describing to me, you have forgotten about the student. Because it's very clear in the student rights, right here, what are the school's responsibilities? Let me just read it for you, and I think you have copies there. Even if a student, this is how important it is for schools and school systems to address complaints by students. Even if a student or his or her parent does not want to file a complaint or does not request that the school take any action on the student's behalf, if a school knows or reasonably should know about possible sexual harassment or sexual violence, it must promptly investigate to determine what occurred and then take appropriate steps to resolve the situation. Promptly take steps to investigate. You have shared with me, Madam Vice Chair, that you did not, there wasn't an investigation, there was fact-finding, correct? Have you started the investigation? Has the investigation on the student's complaint of sexual harassment started?
Like I said earlier, Senator, yes, we just did fact-finding, but we did request the AG to come in and please do an internal investigation.
Senator, Guam Police Department was in Tizen this past Monday and started the investigation.
Was the investigation, Mr. Torres, on the sexual harassment complaint, or was the investigation on the complaint of extortion?
I believe both.
Okay, so was the investigation based on your report to the police department? Did you report to the police department the complaint of sexual harassment? Did the board do that, just as the principals are required to report it?
No, we did not.
Okay. So I just want to underscore here, a criminal investigation into allegations of sexual harassment or sexual violence does not relieve the school of its duty under Title IX to resolve complaints promptly and equitably. Equitably, that means that you have to protect the rights of the accused, and you also have to protect the rights of the complainant. Title IX requires that each school publish a policy that does not discriminate on the basis of sex in its education programs and activities. This notice should be widely distributed and available on an ongoing basis. And the policy must state the inquiries concerning Title IX may be referred to the school's Title IX coordinator or to OCR. When you started to talk with the student, there was conversation because you were trying to mediate, right? Did you explain to her her rights? The right for her to know when the informal investigation was going on, that she had the right to know that you had to tell her when the fact-finding ended and then when the formal investigation would occur? Did you tell her about her right? Did you offer any kind of support in a way that if she needed representation, did you offer her that some type of support to say, okay, I understand that you have this. Do you want someone to represent you? Do you need someone to provide you counseling and how to go about doing this and going through this complaint? Did you advise her of her rights?
We did not.
Okay.
Just so it's clear, because I don't know if the, on both of those questions asked by the chair, you said no. Is that correct?
During our attempted mediation, no, we did not.
Thank you.
Madam Chair,
Yes.
you alluded to the questioning of whether or not an offer has been made to the complainant of what resources are available. I met with the individual. I did make the offer to her and another, the accompanying party, for counseling. She did inform me that she was offered one at the Department of Education, and she turned it down. And I also offered her the one at the Department of Guam Behavioral Health and Wellness. She did not respond whether she wants to take it or not. But yes, the offer was made.
There is a difference between counseling and counsel. Was any offer made to provide her with either legal counsel or assistance in that kind of counsel?
Okay. Thank you, Senator. Yeah, there is a big difference. No, my discussion with her was strictly counseling, not counsel.
Mental health counseling,
That's
as
correct.
opposed to assistance
That's
in
correct, legal.
representing her.
That's correct.
Whether or not it was legal or even like at civil service, where someone who has knowledge of how to be able to maneuver these things at GDOE
That is
could be her assistant. There was nothing.
No, again, I repeat, I offered her counseling, not legal counsel.
Was there ever an instance where the child was separated from adults and was speaking to any one of you? Was there an instance or a time where the student was alone in a room with just the two of you, or you without an adult with them, a parent or someone who could?
First of all, let me clarify that I was not at the May 23rd meeting. I was off island. It was around June 16th when I was approached by an individual who came to present to me some documents. And somewhat surprised, what is this document? And so I said, can you just brief me about it? And then they said it had to do with some allegations. I said, well, you know, it's really not fair for me to make any comment. Please allow me to read it over, but I'd like to meet continue on this meeting with you tomorrow and the victim or the student. I'm not too sure whether or not, I'm almost sure I did, but I stand corrected if not, of mentioning to bring the parents. They left, this individual left, and then on the following day, they came about 1:50 in the evening, in the afternoon, and I said, I would like to meet with the student privately. Come to think of it, let me go back. Yes, I did mention to bring the parents. Yes, I did. Thinking that this is a minor, not knowing she was 18. The first question I asked her was, is this something that's... But anyway. And then after that, somebody walks in and presents me a document and says they filed with the police department. I didn't want to say anything because I don't know what was being filed. I said to the individual that came to me, I said, I want you to know that I am required to let the superintendent know this, if he is not aware. So they knew that I was going to meet with the superintendent. I met with the superintendent at 2 o'clock, the following day, this following day, at 2 o'clock, shortly before 2, and I shared it with him. That evening, I went to the meeting, 21st, and I kind of kept quiet, waiting to see what's going to happen. When nobody knew anything about the police work, I pulled it out. And I informed them that a police report has been filed.
Was there anybody with the student during our attempted mediation? Yes, the parents were there and a substitute teacher.
You had 9 meetings that you had published through, I think that was a press release, that you had 9 meetings in attempting to mediate this. This was in the press release, I believe, that was signed.
There were no 9 attempted mediation meetings.
Phone calls as well as meetings.
So that wasn't that, I forget the date of that
There was
press release.
one with just the 2 of us, and when there was a request to meet and continue the attempt to mediate with other board members, we accommodated that request. Unfortunately, the complainant did not show up.
But so there was never a time when the student was in the room with other board members and no other adult was there present?
No, there was never a time.
Mr. Torres, did you want to say something?
That's what I just said.
I'm
Without name, I did. There was always an adult.
That was representing,
That's correct.
either a teacher or a student or parents?
And yes, ma'am.
Always.
Yes. And during our first attempted mediation, we did let the complainant know that we do have a school psychologist available if she wanted to avail herself the opportunity to receive counseling.
Well, one of the core principles of protecting those who make allegations is to make sure that there is no retaliation, right? And their privacy is also to be protected in order to ensure that the future complainants will not hesitate to make a complaint. And this is why this whole process, the procedures you have, the processes you have taken to address the student's complaint, especially in light of the fact that it's against the superintendent, has to be very clear, has to be transparent, and that it is the same or very close, and it is based on the adopted policies, whether it's local or federal, because we're also bound by the federal policies like Title IX.
I just want to assure all the senators that there was never, from any of the board members, to disregard and not handle the complaint of the student. That is why all the documents that have been received have been transmitted to the legal counsel of the department, with the understanding that he is to work closely with the Attorney General and to take this matter urgently and to provide guidance to the board.
Until Board Member Addis spoke, I hadn't thought about the issue of retaliation. But the filing of the meeting on the 22nd or the 23rd, well, no, 21st and 22nd, was after he had announced that he had been told that the student had filed a police complaint. Is that correct? I see you nodding, Ms.
That's
Nerissa.
correct.
I don't know any other definition of retaliation than if you were going to file extortion, it should have been filed as soon as the offer was asked for whatever amount of money or whatever. It sounds like retaliation when all of a sudden it's someone comes into the board meeting and says, I just want you all to know that a police complaint has been filed and has been presented to me. I had never even thought that. But that to me is classic retaliation.
So at this point, let me just summarize the steps that you have taken. Can you just, so you basically have not started the internal investigation yet? And what if the Attorney General states, I can't provide you the assistance for an internal investigation? How would you proceed?
In one of our board work sessions, that if the Attorney General decides not to move forward with the investigation because they feel, for instance, that they may not be the appropriate agency to do so, the board has discussed the possibility of probably requesting another public agency to help us conduct the internal investigation for the board.
Okay. So, board members, just to be clear, your internal investigation, there was already a complaint that was filed with the police department. So that's a criminal investigation. And there are two investigations going on. Based on your testimony, there's an investigation regarding the complaint of extortion that had been filed by the superintendent and supported by the board. And then there is a complaint by the student for sexual harassment or sexual misconduct that the student had filed. So that's going on in the legal system. For the board, your internal investigation really should focus on the policies and adherence to policies. Did you, at this point, and so if you, at this point, citing all of those policies that govern the Department of Education, federal and local, and even your adopted policies, you would have to conduct that investigation. And you certainly can request the help of another institution or another agency that has a level of expertise or experience in this area, right? And that would be wise. But at this point, what you have actually revealed to the community is this. Is the complaint of the student has not been handled in a timely manner, and it has been to date mishandled. So let me clarify the meaning of what has occurred here today. I'm not trying to prejudge the results of your investigation that has yet to occur, and I have no ability to really know what happened between the superintendent and the student, and if anything even happened at all. But I have the responsibility as the chair of this committee to ensure that the Guam Education Board follows the procedures, the processes to safeguard the rights of students as well as the working professionals, and that includes the superintendent. This is a difficult lesson to learn, and it is particularly awkward for the Guam Education Board to get involved in this process because it normally wouldn't. You're not involved with operations. Under normal circumstances, you would be listening to the superintendent give a report about allegations, investigations, and conclusions. But in this instance, since the complaint was against him, you inherited the responsibility to investigate and to come to a conclusion without him. But he was clearly involved in your deliberations. And fact-finding by not placing him on administrative leave immediately, as is the case with every other DOE employee. You now acknowledge the need to have an independent investigation in which will be presented to you for your consideration and action. So do all of you agree with this approach as we sit here today?
I agree.
So if so, are you now willing to acknowledge that all previous conclusions about this matter were premature? Because you did not take the steps for an independent investigation. If not, I recommend that you seriously think about this because the processes you used up to this point are legally questionable and will subject the department to further harm in the future and severely damage the goodwill of our system in the eyes of the public and especially the eyes of our students. Do you have anything else? Speaker? Okay, well, I thank all of you very much. Si Juice Maasi for your presence this afternoon. This oversight hearing. The oversight hearing meeting is now adjourned and the time is 1:15 p.m. Thank you.